Hello, everybody. It is Jay here, back with Law, Liberty, and Logic. And if you're just tuning in for the first time, make sure you hit the like and the subscribe button so you can get all the latest updates whenever I go live or do an upload, helping you understand more of the legal nuances of the world. And as always, this is just for educational purposes only. If you have a specific issue, of course, you should speak with your local attorney so you can get more clarity on that. But without further ado, we're going to dive right into the topic today. We got an interesting one. We're going to be looking at compelled testimony. So compelled testimony is where someone is being told that they have to testify in court or face some consequences. So it's kind of an interesting, nuanced topic, but we're not going to get into all the weeds, just kind of the main concepts, focusing on just one case. And again, just as a general reminder, this presentation is for informational purposes only. It's not intended as legal advice. Of course, you should seek an attorney if you need legal assistance on your specific issue. But this is a great way to kind of get a sense of the generalities and to think through things. So the key issue here that we have to think about is the Fifth Amendment. So the Fifth Amendment is this backdrop under federal law, this protection against giving testimony that could potentially incriminate yourself in a situation. And the amendment says specifically that no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. And now we get to the important part we're focusing on, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So there's a lot in the Fifth Amendment, as you could see, but we're just focusing on the blue. Nor shall be compelled in any criminal case to be a witness against himself. So, these types of background issues are very important because it's part of the federal Constitution and, of course, incorporated as a minimum against the states, right? The right against, self-incrimination applies in the same way that, your First Amendment concepts apply. So the key question we're thinking for ourselves is, could courts compel testimony if immunity for the testimony was offered, right? Because we just saw you're not supposed to have yourself be put in a position where you're being forced to give testimony against yourself. You can't be forced to testify, in a criminal case against yourself and to, basically have the government use yourself against yourself with your own testimony. It's supposed to be this kind of protection to make sure that people aren't being persecuted wrongly and being pressured to make themselves out to be something, mostly just to, be a kind of a safeguard against people possibly being bullied into confessing something about themselves that maybe isn't even true, right? So it's this idea that someone shouldn't, be forced to give testimony against themselves. However, there is a way around this that courts have found and has been codified in federal statutes. So courts reasoned that if immunity was offered, then key testimony could be obtained that would enable prosecution of greater crimes. So it's this idea that, how about you are forced to give testimony, but it can't be used against you, right? That's the thing that was thought about. And the reason why is because if you have a smaller player witness, you could have them testify, potentially catch a bigger crime cartel, right? They go after the small fries or the small fish, get them to testify, give them immunity, but because they give testimony, now you get the big orchestrators of a bigger, crime situation, crime syndicate. That's kind of, the bigger thought there. So the key case where this line is drawn is Castigar v. United States, 406 U.S. 441. It's from 1972. That is the decision from the U.S. Supreme Court. In this case, the petitioners were subpoenaed to appear before a United States grand jury in the Central District of California on February 4th, 1971. We're not going to get into the weeds of what their circumstances were. We're just going to focus on, the legal issues. So the government applied to the district court for an order directing petitioners to answer questions and produce evidence before the grand jury under a grant of immunity conferred pursuant to 18 U.S.C. sections 6002 to 6003. So in other words, the court said, hey, come testify. We're going to give you immunity. Here's the federal statute that says that we can do this. And then the petitioners opposed the issuance of this order. They said, no, we don't want to testify. they contended primarily that the scope of the immunity provided by the statute was not coextensive with the scope of the privilege against self-incrimination, and therefore was not sufficient to supplant the privilege and compel our testimony. So they made this argument back in the 70s that, hey, you're saying you're going to give us immunity, but that's not enough. It says in the Constitution specifically, you shall not be forced to give testimony against yourself. Now, a literal reading, an originalist reading, probably that would be the case. You would think, actually, this literally says you can't be compelled. So you'd think that should be the case. You just simply cannot be compelled. Of course, courts and judges like to get a little activist there instead of originalist or literalist or textualist and find ways to work around that. So like it or not, that's the situation that we're heading into now, that they're not literally saying, oh, you absolutely could never do this. So the district court rejected the contention and ordered petitioners to appear before the grand jury and answer its questions under the grant of immunity. So the district court's like, hey, we'll give you the immunity. Get over here. The petitioners, they appeared but refused to answer questions, asserting their privilege against compulsory self-incrimination. Very reasonable, right? You have a Fifth Amendment right to not incriminate against yourself. You should be able to remain quiet. But the court found both in contempt because they said, we gave you immunity, and committed them to the custody of the attorney general until either they answered the grand jury's questions or the term of the grand jury expired. And the term of the grand jury could be a long time. Could be a year and a half. You never know. So that's a long time to sit in jail, potentially waiting for this to close. So the U.S. Supreme Court granted certiorari to resolve the important question whether testimony may be compelled by granting immunity from the use of compelled testimony and evidence derived therefrom. So the use and derivative use immunity. So we're going to explain what that is in just a moment, what it means to have use and derivative use immunity. But the Supreme Court said, hey, this is a really important thing to clarify. They said, or whether it's necessary to grant immunity from prosecution for offenses to which compelled testimony relates, which is transaction immunity. There's another key term, which I'll explain later, but the question of to what extent immunity needs to be granted to be able to overcome this Fifth Amendment protection against self-incrimination was what the Supreme Court was entertaining here in the early 1970s. So let's define these terms to make it clear. A use immunity. So this prohibits the government from directly using the compelled testimony itself as evidence against the witness in any criminal prosecution. For example, if a witness is compelled to testify about their involvement in a crime under an immunity agreement, a prosecution cannot introduce that testimony as evidence at a trial against them. So use immunity means, hey, we made you testify, and now that specific testimony can't be brought up and used against you, right? They can't take that literal testimony and then say, ha, you admitted that you were part of this crime. More, on the face, very easy to see. Derivative use immunity, this is where it gets a little bit more interesting and tricky. It says this extends the protection beyond the testimony itself to prevent the government from using any evidence derived or obtained as a result of the compelled testimony. This includes information, leads, or other evidence that the government discovers by following up on the witness's statements. For instance, if the compelled testimony leads investigators to a new witness or a piece of physical evidence, the prosecution cannot use that derived evidence against the immunized witness. So derivative use immunity is not the words themselves, but if someone is leaned on, they're like, all right, tell us what you know. And they say, well, go to this warehouse and there's this car and inside you'll find this. Well, they can't use that physical evidence they found because that specific tip against the person who's compelled to testify, right? So derivative use means they use the information gained from the testimony, and it's that specific thing from the witness that allows the investigators, the police, the prosecutor to come together and figure out more information about, what they can uncover with a certain criminal act or orchestration, right? So use immunity, the specific testimony. Derivative use, using the information from the testimony to find new leads or information, based specifically on what that person said. So the court in Castigar said that the prohibition on use and derivative use of compelled testimony was sufficient to protect the Fifth Amendment right against self-incrimination. So the court here is coming in and they're saying, okay, if you say you give immunity for the use and the derivative use, so both of those, then you can compel the testimony, right? So unfortunately, no literal reading of the Fifth Amendment. Another shame as the Constitution gets squished down and not literally applied there. But the courts are basically saying, okay, we'll let you have compelled testimony, but you got to give use and derivative use immunity. And then, okay, that's okay. You can compel a testimony then. So even though the petitioners argue that there could be future prosecution somehow from the evidence obtained, The court said the prohibition on use and derivative use from compelled testimony, as noted in 18 U.S.C. Section 6002 to 6003, was sufficient protection for Fifth Amendment purposes. So the court just emphasized, yeah, you know what? Maybe something down the road might be found and this or that, but that's not going to prohibit them from saying, okay, we're compelling your testimony as long as we give you these two types of immunities, the use and derivative use. So what that means, though, is that the prosecutors would have to show that their information was independently derived and not from the compelled testimony if they made a new prosecution case. So in this case, if the prosecutors came after a witness, maybe they're a small fry in a big mafia at the bottom, and they got some information from them, they couldn't use that information, but maybe something independently of that witness that they found completely independently from the witness could be later used to prosecute the witness technically. So the witness is not totally off the hook, right? If they had transactional immunity, then they would be totally off the hook. Anything and everything covered, you're immune. It's just use and derivative use. So there is that lingering issue that somehow independently they're able to figure out something to get the witness, but that's, kind of the limits of this case. And that's kind of where they drew the line. So again, the court rejected transactional immunity as a necessary requirement for compelled testimony. And again, transactional immunity means no prosecution for the offense or transaction discussed in the testimony, regardless of the source of evidence, right? So transactional immunity, again, means any possible prosecution, whereas use and derivative use is just limited to the testimony and things found directly from the testimony. So if the state could obtain evidence independently from the compelled testimony, the state could still potentially go after the witness and participants who have testified with use and derivative use immunity. And interestingly enough, prosecutors could also offer transactional immunity regardless if they so choose. So a prosecutor could say, look, I want your testimony so bad. I want you to be so transparent with me. We're going to give you transactional immunity on top. It's possible. Maybe a prosecutor is just feeling very generous because they're like, you know what? I want to make it so clear that we want to get every single piece of information of this person. We want them to feel totally comfortable because we want to expose this much bigger crime syndicate. And so if they feel, comfortable about sharing every possible detail, then maybe, transactional immunity is fine because it's worth going after the bigger orchestration because of what they could potentially provide. It's possible. It's just not mandatory. The prosecutors don't have to offer transactional immunity to comply with the Fifth Amendment. They only have to use immunity for the use and derivative use. So there's, obviously nuances with circumstances and courts, can get around the Fifth Amendment protection against self-incrimination by offering the use and derivative use immunity protection. There's always going to be some little factors and this or that court cases, that kind of distinguish between those things. But generally speaking, courts are going to be able to work their way around the Fifth Amendment by giving that specific immunity. So if it's offered, if this protection is offered generally, and there's still a refusal to testify, the witness could be held in civil or criminal contempt of court, depending on which division the case is located in, right? If it's a civil case, criminal case. So that's where it gets tricky. This is where, someone's in the weeds of the legal, nuances and being afraid about what's going to happen next, right? Someone is told, oh, you got to testify. And they're like, no, Fifth Amendment. And the court's like, okay, we're giving you immunity. If you don't testify at that point, and and everything else is otherwise legal, you could potentially get sanctioned. And in a civil context, the imprisonment lasts only as long as the witness persists in refusing or until the proceeding, like the grand jury term, ends, which could be pretty long. So that depending on how long that grand jury's investigation going on, someone could be in there for a very long period of time, many, many months, maybe a year, maybe more. So they kind of put this pressure on people to testify saying, okay, if we give you immunity and you don't talk, we're going to lock you up, which of course, is pretty abusive when you think about it, especially since you're supposed to have the right against self-incrimination and not have to be compelled to speak. But that is a reality. And in a criminal context, it could be much worse because if the refusal is deemed willful and obstructive, the court may impose a fixed term of imprisonment or fine as punishment for disrespecting the court's authority. So, with the criminal, it's more serious, obviously, than civil, and they could add on extra sanctions that are, going to put somebody in a situation that maybe they don't want to be because they're willfully obstructing at that point. Again, whether you like it or not, whether you think this comports or not with the Fifth Amendment, That's what it is, unfortunately, at the federal legal landscape that backdrops the Fifth Amendment for everybody everywhere else as minimums. So, in summary, if one is given use and derivative use immunity, generally speaking, compelled testimony will be required with possible sanction if the person refuses. And you have a good lawyer, they might be able to argue about some other risks that if someone testifies, they're going to be in a threatened or life-threatening situation. Maybe like, oh, we'll have to put you in witness protection or something like that. Who knows? But ultimately, the court does not have to accept those arguments. They don't have to, go along with it or prolong things. The court can say, okay, well, that's nice, but we're saying if you don't testify, we have X, Y, and Z sanctions. They're going to, go against you now if you don't do that. And usually it's going to be lockup for a while until, someone starts squawking. So it's just an unfortunate factor there. And it's something that if, someone's in a tough situation about and they're afraid, oh, I'm worried, whether it's they're going to be gone after or they're worried about some type of thing that's self-incriminating, that, the best thing they can hope for is that they just have really good immunity and maybe some witness protection program if they're worried that, oh my gosh, someone's going to come after me if I talk, which does happen. I mean, there's lots of people who are in witness protection programs in that situation. They get some immunity, they talk about a grander scheme, and then they have to go into hiding as there's a broader prosecution of a larger, wider body of criminal enterprise. So it's just what it is, and it's otherwise lawful, and that's basically how it's going to fall at that point. So I appreciate everyone here coming on by to check out this legal educational lecture. So if you haven't, of course, please do like, share, and subscribe. I love it when people share my videos and give the thumbs up. Throw a comment down below. Sometimes I read comments and even look for potential new ideas. I think this video even was something that from seeing someone's comment, I actually was like, ooh, that could be a fun topic to talk about immunity. So I hope everybody has a wonderful rest of their day, and I'll talk to you soon with some more legal issues. Take care, everybody.